And stakeholders in the justice sector say the need for people to access justice to enforce their fundamental rights is necessary in the face of rising concerns bordering on violation of persons' rights. This was the position echoed at a national town hall meeting on strategic litigation in advancing human rights in Nigeria, an event organized by the National Human Rights Commission in Abuja. Well, this event marks 15 years since the enactment of the Fundamental Rights Enforcement Procedure rules in the country. The legal framework upholds the rights and dignity of every person, whether citizens or non-citizens. Now, the aim of the town hall meeting is for the stakeholders, including rights activists, to better explore ways to break down all barriers that prevent access to justice for all, particularly those seeking redress for violations of their rights.
Our mandate to safeguard the rights of every Nigerian and non-Nigerians living within our border is a duty we do not take lightly. Access to justice, therefore, is indispensable in this mission. Justice is the mechanism through which the vulnerable find protection, the marginalized gain a voice, and all Nigerians receive the dignity they are inherently owed.
We must work together to create a future where litigation is formidable and accessible tools for upholding human rights in Nigeria. This is a collective responsibility. We must demand accountability from state actors and speak out against injustice in the face of these challenges.
NGOs and human rights activists who are actually supposed to be busybodies can now take interest to enforce the rights of third parties as against those who are oppressing them or those who are violating them. Now, it's not only about local standard that has been removed as a clog, as a problem, but the idea of limitation of time. It means that you can actually enforce human rights matters, despite the fact that they've taken quite a long time.
A human rights lawyer and activist Inibehe Effiong joins me now for more on this. Great to see you, Inibehe.
Good to see you. Always a pleasure.
Yes. So let's start. It's 15 years, as I recall, since the enactment of the Fundamental Human Rights Procedure rules.
Yes.
So why is it still difficult for Nigerians to get, their fundamental rights enforced?
I think
what are the factors?
Many factors account for the inability of Nigerians to maximize the fundamental rights guaranteed under Chapter 4 of the Constitution, from the right to life under Section 33, to the right to dignity under Section 34, to the right to liberty under Section 35, the right to fair hearing under Section 36, the right to privacy under Section 37, the right to religion under Section 38, freedom of expression under Section 39, association under Section 40, freedom of movement 41, freedom from discrimination 42, property under 43. These are of course, 43 and 44, the right to property. These are the constitutional rights guaranteed under Chapter 4 of our Constitution. And of course, there are limitations provided under Section 45. However, Section 46 says any person whose right has been, is being, or is likely to be infringed may approach a high court in the state where the infringement occurs for redress. So the Constitution has given the basis for ventilating grievances of Nigerians whose rights have been violated. Now, before the introduction of what we call the FRED rules, the Fundamental Right Enforcement Procedure rules in 2009, by the then Honorable Chief Justice of Nigeria, we had the previous fundamental right rules, which, for example, require that before you can enforce a right, you should go to court to seek leave. Now you don't need leave anymore. You don't need local standards. My colleague, Mr. Frank Tite said, you don't need those things anymore. But guess what? We still have institutional weaknesses. Our institutions are weak. You go to court, right? Even the officers, the institutions that are violating your rights, like the police, for example, a notorious culprit, the police will be the one to even challenge you to go to court. They will detain you illegally, you go to court. You get orders, those orders are not obeyed. Disobedience to court orders is one of the major reasons why the fundamental rights of Nigerians are not being respected. Of course, lack of resources. Many Nigerians cannot afford legal representation. Many Nigerians cannot afford to retain services of lawyers. And even though there are some of us that try to offer pro bono services as much as we can, and you have the Legal Aid Council, the National Human Rights Commission, and NGOs and so on, the reality remains that the labor is much, but the laborers are few. So very few persons can afford the resources and the capacity to go to court. The other problem is the delay in the judicial process, in the adjudicatory process. You file a case, even fundamental rights. I have fundamental right cases that I have litigated over 3 years in court. I have fundamental right cases that are still pending, that you will even be struggling to get dates in some of the courts. The judges are overworked, the cases are too many, and that is why one of the recommendations that we made today at the National Symposium by the National Human Rights Commission is to say that why can't we have specialized courts for fundamental rights? Why can't we have, for example, at the Federal High Court in Abuja, maybe 1 or 2 judges designated to handle fundamental right cases? And the same thing for other courts in the country. Maybe that will go a long way.
Ingrid, you've answered my next question to say, I mean, given all of these challenges you've highlighted, an average Nigerian whose fundamental rights is being breached will just say, "Na God hand I dare, I leave it to God." But perhaps if we had special courts,
yes,
and you've answered that. Something that came up at the symposium today also was the strategic litigation,
yes,
as a tool to advancing human rights. How effective is this approach, and how does it really work? What difference will it make?
Today, we came together to examine strategic litigation and public interest litigation. I was one of the panelists who had the privilege of, having a conversation today on that matter. Now, what we have seen is that it appears that under the military era, under the military regime, it seems that access to courts and in terms of the court being receptive to public interest cases, it seems it was even better under the military. And I say that with profound respect to the judiciary and with all sense of responsibility as the lawyer. Today, it looks like it is more difficult to go to court to pursue public interest cases. You even have Nigerian judges today, not all judges. Some judges in Nigeria, some in particular, I don't want to put names on record because I'm on national television, even awarding punitive costs against lawyers who go to court in the public interest. They will dismiss the case and say, "Oh, you don't have local standard," and then they will even award monetary penalty. In fact, in some cases, they will say, "Pay it personally." All the lawyer does is to go to court and defend public interest, to fight public interest cases.
But local standard doesn't work in this instance of
fundamental rights.
Fundamental rights, as we have been told, does
yes,
it?
Of course, under the fundamental right rules, local standard, that requirement ordinarily is not no longer required. It's no longer a requirement. You don't need local standard. But the point I am making is that when you have conversation, the practicality of enforcing these rights, what those of us, practitioners, that have to deal with this daily in our courts face with, there are institutional issues that have to be addressed. There are legislative issues that have to be addressed. One of the recommendations that we are also making is that lawyers who are going to court or cases that are fundamental right cases should be called out of turn. For example, you have a situation where someone has been incarcerated. Someone is in custody. You file a fundamental right application. You go to court on a particular day. You look at the docket of the court. Look at the cost list. 20, 30 cases are listed. Why can't fundamental right cases be called out of turn? Especially when the liberty of a citizen is at stake. I have cases where the liberties of my clients have been at stake, or persons whose rights have gone to court to enforce. You wait for 3 weeks, sometimes a month. The cases are not assigned. So these are some of the issues that have to be tackled.
Okay, so very quickly, because it also talked about those who should protect these fundamental rights, being those who actually violate them, such as the police.
Yes.
So do we need to reorientate our law enforcement? And I wanted to ask you, given your practice and experience as an activist yourself, where do we see the most frequent breaches of Nigeria's fundamental human rights?
The Nigerian police force is the most egregious, the most unrepentant, and the most reckless violator of human rights in our country. And I say that with that apology. The reason why the custodial centers, the formerly called prisons, are congested in our country today is largely because of the police. The police accounts for the most brazen violation of the rights of Nigerians. On a daily basis, Nigerians are being assaulted by the police. People are still being arrested in lieu. They are looking for you, they cannot find you, they arrest your spouse. You wake up in the morning as a man, in the morning, your wife or your husband doesn't greet you, you can go to the police to make a complaint. The police will arrest the person. Notwithstanding that it's not even a crime.
Is it that the police doesn't understand what fundamental human rights is and how they should protect it? What exactly is the challenge?
No, it is just an entrenched culture of impunity. That perception that nothing can happen. Look at the case of the minors. The IG told us he was investigating it. Why those minors were malnourished, why they were not properly catered for. Have you heard anything? And guess what? When you go to court and get judgment against the police, we have this monstrosity, this monstrous law called Sheriff and Civil Process Act that says you must seek the consent of the Attorney General to enforce judgment against the government. So when you go to court and get judgment against the police, you cannot enforce it. I doubt if 5% of lawyers, in fact, I'm being generous, if 2% of lawyers in Nigeria have been able to enforce monetary judgment against the police. That simply has to change. We must repeal that provision that requires the consent of the AG. And then we have, guess what? We have human rights departments in almost all police formations in our country. You go to the police stations, they write their bail is free. The AG know that is a lie. They are still extorting Nigerians. Look at what is happening on the road. Every Inspector General of Police will tell you they are going to address human rights. And the other point I want to stress, the problem is not the laws. Because we have the new Police Act 2020. When you look at the objective of that act from section 1, it is meant to advance human rights. But it is basically a dead letter law.
Okay, so in wrapping up now, you made some recommendations at the symposium today. Yes. We also had the National Human Rights Commission. How well will you say that has fared? But in wrapping up, what are the immediate steps that need to be taken to ensure that Nigerians' fundamental human rights are protected and ensured as enshrined in the Constitution, which you have told us about at the beginning of this conversation?
Thankfully, we have the National Human Rights Commission Amendment Act of 2010 that has given the Commission extensive power, including the power to carry out investigation into human rights violations and award compensation when necessary. And in fairness to the Commission, they have been very remarkable. From when Professor Chidodi Nkalu was in charge, the Executive Secretary, and under the current Executive Secretary, Ojukwu, SAN, they've done very well. The National Human Rights Commission, I dare say, I don't patronize institutions of government easily, you know that.
I know.
But I dare say today that it is one institution that speaks to the fact that institutions in this country can work when they are allowed to function independently. And that is what they have demonstrated. Now, what we need to do is to strengthen our institutions, strengthen our courts. The Nigerian Bar Association also has a role to play. And that is why I commend the current president of the NBA, Alpha Mozikwe said, who, when he was elected, decided to set up committees, including the Citizens Liberties Committee, of which I'm privileged to be the secretary, to basically go to custodial centers and ensure that Nigerians that are detained illegally, that people's rights are violated, that they have access to lawyers, and that the NBA also begin to watch what is happening, across the country. So the civil society has a role to play. The media must continue to shed light on this issue, to ensure that at the end of the day, that the rest of Nigerians are respected. Because when we say it is a democracy, it is not about roads. It is not about building hospitals. It is not about provision of borehole water. These are things that the military can do. Some of the best infrastructures we have in Nigeria today were constructed under the military.
So it's about the people.
Democracy is about the people, it's about human rights.
Okay.
It's about freedom of expression.
Thank you very much. Human rights lawyer and activist Enibehe Effiong, thank you so much for being on the news tonight.
Thank you for having me.
And we're watching the space now that you're secretary of that commission by the NBA to ensure the rights of Nigerians. We'll be watching to see what you're doing with that as well. Thank you.